We're on the record.
Okay, the July 10th meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force is now in session.
On the call of the roll. Member Hinsey.
Present.
Hinsey present. Member Moss.
Present.
Moss present. Chair Kanata.
Here.
Kanata present. We have a quorum. There are no agenda changes that I know of. Next on the agenda, item number 2, approval of the May 30th Compliance and Amendments Committee meeting minutes.
I do not have any recommended changes, so I would move to accept the minutes.
I'll second.
Okay, so
Wait.
public comment on the motion for approving the minutes. Seeing no public comment, can we take this by acclamation?
Sure.
Okay.
The motion to adopt the minutes have been approved without objection. Next on the agenda is item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Any public comment? Seeing none, public comment is closed.
Next on the agenda, item number 4, file number 16117, hearing on the status of the order of termination. Complaint filed by Ray Hartz against City Librarian Luis Herrera and the Public Library for violating Administrative Code, Section 67.29-6, by failing to maintain written agreement with entities collecting and maintaining funds for the purpose of carrying out or assisting any city function to abide by the Sunshine Ordinance. This matter was heard at the last Compliance Amendments Committee, and I believe you had instructions for them to, and I'll leave it at that. We did receive information at the meeting today that was just provided from the public library.
So I think I would like. Well, this is really loud. I think it would make sense for us to ask Mr. Hartz if he thinks that we should continue this based on the new information that has just been introduced.
Okay, Mr. Hartz.
Absolutely not. The memo is dated July the 7th, which was last Wednesday, and the library, I don't know when they got it, but basically they could have sent that to you and made it available. They also could have made it available to me, but they don't like to do stuff like that because then people can read what they wrote and come up with a reasonable argument. I see no reason to believe that the library will do anything different in the future. The intent of the memo, from what I have briefly read, is the city attorney saying to them, you don't have to comply with what the task force has said you have to comply with. And so since that's contrary to what the task force has already decided, it's kind of a meaningless exercise.
How much time do you think?
I mean, this isn't a hearing, right? This is where
It's not a hearing. You
No.
can make that determination. We can, if you'd like to allow for any presentations, I would suggest a standard 3 minutes.
Right.
let's
But
bring the.
do we want to try to digest this first, or give us?
Sure.
Yeah.
I mean, I'm going to continue reading it. So
Yeah. Why don't we give us like 5, whatever minutes, few minutes, just to try to digest this, and then we can hear from.
Well, we'd like to take a brief recess so we're not recording dead air.
Yes. Let's. Member Moss. How much?
5 minutes.
5 minutes.
5 minutes.
Okay. Well, let's take a 5-minute break to go over this. Okay, we're back. Mr. Hartz, you have 3 minutes, please.
Should we start with the library first? Sorry. So they've explained what they've handed to us.
Yeah,
That would be my preference.
Okay. We have a representative, the respondent, please. So can you
Yes.
explain the documents, please?
Sure. Good afternoon, committee members. Maureen Singleton, Chief Financial Officer with the library. The memo that has been provided to you from the library was advice that was provided from the city attorney on which section of the Sunshine Ordinance would be applicable to the outside funding monies. A point of clarification, we did receive this memo on July 7th, which was Friday, not last Wednesday. And so we are providing it to the committee today. You'll see in the memo, the city attorney's office did a review not only of the Sunshine Ordinance itself, but various cases to determine what would be applicable to the Friends money and which compliance would be required. Based on their review, that they drew the conclusion that the context is important and that this section of the Sunshine Ordinance 67.29-6 is applicable just to that section rather than the entirety of the Sunshine Ordinance. This is consistent with the verbal advice that the city attorney has provided us in the past and was the reason for us to give you that one-page document from the Friends that they had signed where they agreed to comply with that section of the Sunshine Ordinance. Given that our MOU that we are still in the process of drafting with the Friends of the organization, Friends of the Library organization, our MOU will reference the signed document that shows that we are in compliance by having something in writing and signed from the Friends that they will comply with that section of the Sunshine Ordinance. And we hope to have that MOU finalized in the near term, and we can provide you a signed copy of that once that is available. But again, this memo is written advice to the city librarian on what would be the applicable section of the Sunshine Ordinance to the outside sources of funding that's mentioned in section 67.29-6. I'm available if you have any other questions.
Thank you. You have questions?
Yes,
for
I
the
do.
respondent?
So can you just tell me again, when do you expect to come into compliance?
Well, we are in compliance based on the advice that we have from the city attorney, and that is the one-page document that's been provided to the Sunshine Task Force already. It was signed on April 26, 2017 by the Executive Director, Marie Sapella, and it talks about compliance with Section 67.29-6.
And you said that there's another, the MOU is being updated.
Right.
So
We
what
are
about
also doing an MOU that talks about different information, how we are interacting with the Friends, our statement of common purpose, and within that MOU, it is going to counter-reference this document, and this document would be attached as part of the whole MOU.
And you had said during your testimony that this Attorney General memo gels with oral advice you'd been given in the past. When was this oral advice given?
I don't have a specific date when the oral advice was given, but there have been different times over the course of our interaction in developing the MOU, is determining what would be the applicable section of the Sunshine Ordinance.
So in other words, the oral advice has occurred since the order of determination was issued?
No, the oral advice was provided before when we were drafting the MOU, and then what we determined, because we wouldn't be ready with the MOU right away, that we did that one-page document from the Friends that they agreed to comply with that section.
But isn't this agreement from the Friends subsequent to the order of determination from the committee, or am I getting the timeline wrong? Like, I don't think this existed before this was heard by the full task force.
We've never seen it before then, correct?
Right.
You had, so my understanding is that there was an order determination, and then it was submitted to this committee. And after that order of determination, we provided the written agreement. We had already started drafting a long while ago an MOU after our last framework agreement expired, which was referencing, as the framework agreement had done, Section 67.29-6. And my understanding in May was when the committee heard this item that there was discussion about whether What was truly applicable from Mr. Hart's perspective and the committee's perspective was the Sunshine Ordinance in its entirety. And so we went back to our city attorney and said, would you please put in writing your oral advice to us on what they believe is the applicable section of the Sunshine Ordinance with respect to the outside funding sources?
Okay, so just for make sure I have the record correct here. So the order of determination was made on March 15th, 2017. This agreement for 6729-6 was signed April 26, 2017. So that is the timeline we were looking at.
And then amended. Or has this been amended since April, or is
No.
this the exact same one?
No,
we
it's
got?
the same one
Okay.
that was provided previously.
Anything else, Member Moss?
Maybe in a bit.
Okay, I have a couple of questions. I mean, you mentioned that context was important, and that the city attorney said that 67.29-6 applied to the monies. And I agree with that, but it seems to me that because the Friends are not donating their own money to you, they are acting as a city for you, for the library, in collecting money from others to donate to you. Is that how that operation works? How do the Friends get the money that they donate to the library?
Individual donors
Right.
donate to them
Right.
On behalf of supporting the public library.
Correct. So the Friends are managing the funds that come into the library through these individual donors. They collect all the money and they pass it on to the library.
A portion of the money comes over to the library,
Right.
yes.
Okay. So
But they are a separate 501c3.
Correct.
They are not a city department.
they're not a city department, but they are acting for a city department in managing this money to send it over. Could that be an interpretation of what they do?
I suppose that could be an interpretation of it, but based on the advice that we've received from the city attorney, that they are viewed as a separate entity and not a city department.
Okay. Yeah, Member Hinsey, do you have any questions? Okay. Thank you.
So, sorry, as I understand it, as I'm reading this advice, the advice is that a judge would perhaps make this ruling.
Right.
Is the library considering going to a judge to have such a finding be made?
No. We're saying if this item were ever to proceed to a court proceeding, that the likely conclusion would be that based on context as well as all this other case law, that the reasonable conclusion would be that the applicable section is 67.29-6 and not the entirety of the Sunshine Ordinance.
But our last decision on this was that we believe it's the full ordinance, and that's what we don't have, we're here to uphold the ordinance. We can only read what the ordinance says. And I don't think decisions can be made on what a judge might likely do. It's different if you came here and said that a judge had said that this is a case and you showed us a court order in which that this was the decision made. It doesn't seem like we're at that stage yet.
No, but we're pursuing an agreement based on legal advice from our city attorney, and feels that what we're doing would be in accordance with what a court would likely conclude, so that we wouldn't be found in violation of the
So why aren't
Sunshine.
you going to a court over this?
I'm not sure why we would go to court over this. We're just saying it's a defensible approach to say that the only applicable section is that.
Okay, thank you. Mr. Hartz?
Questions, or do I just? Number one, the analysis is similar to the Good Government Guide, which the city attorney writes down whatever he thinks is best in the best interest of the city, and then tries to pass it off as some sort of a legal finding. As Member Moss has said, are they taking it to court? No, because I think they realize if they took it to court, the court would say, no, this is not an unreasonable interpretation. The task force is specifically under the law designed to interpret things which are open to interpretation, and it has done so, and it has ruled that the Friends need to comply. Very frankly, over my experience dealing with the library, the Friends, since the inception of the most recent agreement between the Friends and the library in 2003, have never complied with some of the terms of that agreement. They're supposed to report annually certain information about how much money they raised, and they've never done it. And I spent 2 years before City Librarian Luis Herrera finally came out and admitted, no, they've never told us what they raised, and we've never asked. Now I just found out this last month from a reply I got from Ms. Singleton that the requirement that they have a lease on a library portion of the library to run a bookstore, which has again been in place since 2003, and they have never complied with the terms of the lease. It requires that they certify annually to the city library that they have raised in excess of $300,000, and then the library, through its CFO, is supposed to send that to the Department of Real Estate, and I've gotten responses from the Department of Real Estate that shows they've never done this, and that has to do with an abatement of their lease. In other words, they're supposed to pay $774 a month, and if they comply with the terms of the lease, that can be abated to $1 a year. They've never done that. So basically what we're talking about here is getting this group, who's had, in my best ability to evaluate it, more than $80 million passed through their hands since 2000. And Ms. Singleton and the other representatives of the library and the representative of the Friends always talk about this wonderful relationship. Well, if I worked for the Friends and I was getting a $200,000 a year salary and health benefits and everything else out of the pockets of people who thought they were giving to the library, I would think it was a very great deal too. And as I've said before, using the figures from the Board of Supervisors, they authorized in 2015, which is the latest year we have all the figures, that the Friends give a gift up to $410,200, which, if you look at what they admitted on the website Cherry Navigator, in that same year they raised $3.5 million, which means the library got 12% of the money they raised from all these different things. And I think there needs to be an accountability, because the library has no intention whatsoever, because it discloses the bad behavior of the city librarian in setting up the deal.
Okay, thank you. Okay. Member Moss.
Through the chair, is there a representative from the Friends of the Public Library here? I do have some questions for them.
I mean, it would seem to me that since the full committee came to the conclusion that the agreement between the library and the Friends of the Library should stipulate that the Friends abide by the Sunshine Ordinance, that hasn't happened. The only recourse that the Sunshine Ordinance Task Force has to uphold this is to find a willful violation and send it to ethics. Otherwise, there's nothing else we can do. So I think we should discuss that, because we have no capability of enforcing that decision. The enforcement has to come through the Ethics Commission.
I mean, I'm definitely interested in sending this back to the full task force to discuss this matter again, based on where we are in this. I mean, I think that I'm not prepared to close this matter at this point. There's a city memo, which, the city attorney memo may be correct, maybe not, but I'm not a judge, and I can't make a judge ruling, and this committee can't make a judicial ruling, and I don't think we can base a decision on what a judge might likely do based on the opinion of the city attorney, especially not with a opinion from a different lawyer, who's not the city attorney, who would say what, to evaluate this. So, I mean, I would say we should probably send this back to the full task force. I don't know if we need to make it a willful violation recommendation, but is that what it would take to get it back to the full task force?
There's no specific ruling on this or methodology. You can send it back to the full task force with a recommendation to find a willful violation if you would like, or you can send it back to them with a question regarding this specific issue of they've been advised, so forth, in opposition to the task force, the recommendation.
Could we speak to the San Francisco Public Library again? What time period does this agreement cover? Like, how long does it go?
There's no end date on the one-page agreement.
Is the memorandum of understanding that this would be attached to would that have a timeline attached to it?
Yes, so that one would have, I don't have it with me. I believe that it is, there are specific terms and options to extend.
And what happens to, how will this be treated retroactively? Will this be treated retroactively? Will the disclosures be made under 6729-6 for years in the past in which this agreement was not in place?
We will definitely work with the Friends of the Library to provide that information and link it through our website.
I feel like that's something I would like to see. I mean, even if they're going with the 6729-6 is the extent of it, I feel like to rectify the situation, an agreement needs to cover years past. I mean, at least that's my personal thought.
I'm not ready to close this out now because there has been no compliance with what the full task force, with their conclusion of the full task force. So,
my understanding, though, when it came from the full task force to the committee, is it was about that specific section. It was at committee when the interpretation was, or the complaint was adjusted to say that it's the entire ordinance.
that's not my recollection. I remember Chair Wolf.
Well, if you look at the minutes from May 30th, that's when it was clarified by Mr. Hartz that he meant the complaint was to comply with the entirety of the Sunshine Ordinance. His original complaint was just about Section 67.29-6.
Sorry, just going through the minutes here.
Mm-hmm.
Well, I think we should just send this back to the full task force. I'm willing to make a motion on it if that makes sense. So I'll move to send this back to the full task force to specifically look at the question again of whether 6729-6 only applies to that section or requires compliance with the ordinance as a whole. And forwarding along with that the new Attorney General, the City Attorney opinion that probably should have been provided or generated and provided to the committee back in April or back in March when we had this first hearing to begin with.
Mm-hmm.
Second.
Okay. Public comment on the motion. Seeing no public comment. take the...
On that motion, Member Hensy.
Aye.
Hensy, aye. Member Moss.
Aye.
Moss, aye. Chair Kanada.
Aye.
Kanada, aye. The motion passes. Parties will be notified once the matter is rescheduled before the full task force.
Let's go to the next.
Next on the agenda is item number 5, file number 17072, complaint filed by Marvin Lambert against the Historic Preservation Commission for allegedly violating Administrative Code Section 67.16 by failing to make draft minutes of each meeting available for inspection and copying upon request no later than 10 working days after the meeting. This is regarding a June 7, 2017 meeting.
Okay, is Mr. Lambert here? Could you come up and present your case, please? It's 5 minutes, 3 minutes at these.
3 minutes.
Yeah. Okay.
Sorry, point of clarification. Do we need to find jurisdiction
Oh,
first?
You can delay that until the end until
We can
you hear
can make the motions
arguments.
together.
But that's the exact thing. It's definitely what we need to do in this committee.
Eventually you do, yes.
Yeah.
Okay,
So 3 minutes?
3 minutes, please.
Okay, I assume you've reviewed the documentation I submitted. My current claim is against the Planning Department staff and the Historic Preservation Commission for having concealed information from the public by a series of actions that follows a pattern. However, I just received an email from staff that the project sponsor has withdrawn their COA application. This time, I don't know what that means, particularly as to whether a reapplication is waiting in the wings. However, I will advise you, it's my understanding that San Francisco Parks is a partner in the sponsorship, and I'm also considering filing a complaint against them. Unless someone here can provide satisfactory assurances, I'll proceed with my planned statement. The withholding of minutes is clearly a violation of the Sunshine Ordinance. However, this is just the tip of the iceberg. The other violations which I've submitted, while perhaps not specifically anticipated in the words of legal text, are clearly violations of the intent and purpose of the law. These other violations include staff held this item in the dark when they exceeded their authority, proved an administrative COA, in contrast to standard COA, which can only be approved by the Preservation Commission. An administrative COA does not require public notice, whereas a standard COA does and also requires a more extensive application. Staff's effort to railroad through the application without HPC review means that critical information was also hidden from the HPC as well as the public because the commissioners would never have reviewed the item. The minutes provide no meaningful description of how the item was improperly disposed during the HPC meeting. Following the sequence of events I observed, the item was called before the acting chairman could speak. Secretary turned to him with back to the audience, mumbled something to the chairman to the effect that legal had determined there needed to be public notice for the item. The chairman then stated something to the effect, because this was mumbling back with their backs turned, that the item would be heard at the July 19th meeting. So now that's not going to happen because they've withdrawn the application. Due and open process was not achieved in the way the item was handled. The commission took an item that was pending a decision, just swept it aside based on a side conversation between the chair and the secretary with no explanation whatsoever as to what happened. I'm still concerned there will be another attempt by staff to railroad the project through. Therefore, I request all park planning staff work on the substitute COA if that's what happens. Be halted until redress is made and this whole project is brought to the light of day. Thank you.
Thank you. Respondent, please. You have 3 minutes.
Good afternoon, Christine Silva, Planning Staff. On Thursday, June 22nd, Planning Staff received a request for draft minutes of the Historic Preservation Commission hearing held on Wednesday, June 7th. Staff emailed the draft minutes to the requester the following Tuesday, June 27th. The department acknowledges that we exceeded the 10-day window per Admin Code 67.16. It was our oversight to not produce the draft minutes immediately upon request. At this time, the draft minutes have been provided to the requester. Happy to answer any questions.
Okay. Member Moss, do you have any questions?
Yeah, hold on a second.
Okay,
Go for it.
I can start. Mr. Lambert, I have some questions. I'm just trying to figure out exactly who the complaint is against, because you mentioned the Historical Preservation Commission, the Planning Department, and Park and Rec. Are all of them involved in this, or?
Yes, they are. This, if you understand this project, and do you have a background on the project? It's an outside group is proposing to put a Zen rock garden in a park which is contained in a historic district, the Bush Street Cottage Row Historic District. To do that, to do anything in the historic district, you have to get a certificate of appropriateness from the Preservation Commission. So that's what we're talking about when we talk about a COA. Now, if a COA from an individual property owner is deemed minor, planning staff, which supports the Preservation Commission. They don't have their own staff. They're a stepchild of the planning. I hope I don't offend anybody with that. So planning can approve, the staff can approve a minor, and there's a minor change, a specific motion that specifies that. They violated that motion when they approved it. Okay?
Yes, but my understanding of this complaint is that the minutes were, the draft minutes were not available on time.
Perhaps, and this is one of the things I've wondered about if I need to file a separate complaint. Because here's what happened. I'm totally in the dark. They're going to move forward with this. They haven't posted the property or anything. And we found out by happenstance. I challenged the ACOA, and they said, oh, somebody's here to challenge it. We are going to give notice. And so that bought us time. So then I said, I don't understand what happened in the meeting.
Through the chair?
Yeah.
Sorry. So the only thing that we're able to look at today is the issue of the draft minutes.
Well, then I have to submit another complaint.
Probably, and it may not be a complaint that is handleable, well, that the Sunshine Ordinance Task Force may be able to handle if it's not part of the Sunshine Ordinance.
If I explain to you the reason I'm in the dark, I'm trying to find out what's going on.
We're in the dark outside of Sunshine Ordinance matters as well. So if there's things that are required as part of the planning process, that isn't necessarily something that comes under the Sunshine Ordinance. And we'd have to do quite a bit more research. Like we go through all 76 pages in the packet prior to these meetings. And so I understand you're in the dark. Maybe Victor can help you with certain things. But really today we need to look at this draft minute issue.
Wait a minute. Should I file another complaint then?
It doesn't. I'm not sure if your complaint is actually appropriate for the Sunshine Task Force, though.
But right now, all we're doing is we're looking at the issue of the draft minutes.
Right. Our purview deals with requests for data from city data from city agencies and how meetings are conducted. So here, this falls into how meetings are conducted, where they have to have draft minutes available 10 days after the meeting. Stuff that they may do in the future, or because they tabled this because you voiced an opposition, and if they're going to bring it up again, we have no insider jurisdiction over that until it happens.
But I have a complaint about the way the meeting was conducted that generated the minutes. That meeting that I'm complaining about, where they kind of just swept it under the rug here, that was the meeting that I wanted the minutes on so I could understand what happened.
Right.
And the minutes don't tell me anything what happened.
I think that would require... Oh, sorry, go ahead.
Yeah.
But the only part of your complaint about that particular meeting that your complaint is about that's in our purview right now is the draft minutes.
Yes.
So that's the one part of the meeting that we're looking at right now.
Right. So I think you would have to file another complaint.
Yeah, through the chair. If there is an issue with the agenda not properly describing something, I think at that point you are going to want to file another complaint.
Well, there's also the issue of staff trying to railroad something through in the dark with under the radar of public by misapplying a rule of their own. That seems to me to be under the Sunshine Ordinance as well, under the intent and purpose of the ordinance. That's the major violation here. The minutes, they admit they didn't do the minutes. As soon as my complaint was published, 16 minutes later, I got a copy of the minutes. So obviously they were stonewalling me on the minutes the whole time. They had no intention. And the text I've shown you, they said, well, you'll get them when they're ready. And I said, no, I think they're ready now. It's been 10 days, okay? So they admit they withheld the minutes improperly.
And they are admitting to that violation. If you want to file another complaint because of how the meeting was run, if they did not allow public comment properly, things like that, you may do so.
Okay? Thank you.
Okay. So
Through the chair, could the respondent? I got some questions to respondent again. So I believe the chair had asked a question about who should be culpable for this. So originally, Mr. Lambert had named the Historic Preservation Commission. It looks like the planning department has become the respondent here. Who all? I mean, if you're saying that 67.6 was violated here, who actually did the violating? Like, which of those agencies should?
Be named in the complaint.
What's that?
Which of those agencies should be named in the complaint? In your complaint, yeah.
Yeah, in the complaint, it's the Historic Preservation Commission, but the planning department seems to be who had been communicated with here. And so I'm trying to, I think the chair had tried to clarify who should actually be.
So the planning department does support the Historic Preservation Commission. We staff that commission.
So then the complaint should
So
be,
it's the city
it should be against the planning department staff because they're the ones who provide the minutes.
Yes.
Okay.
That seems correct.
Let me ask, should we be amending the title or should we be leaving it as Historic Preservation Commission?
I want to, hold on, I just want to look at the. So my inclination is that we just do both. That I think that if we just make it the planning department, then what's going to happen is that when we eventually get to creating a canon of task force decisions, that it'll just look like the planning department when really this was a problem that happened with the minutes for this particular commission. And I think that we could probably name them both in this regard.
Mm-hmm.
That would be my.
I will
fine.
make that change to the title
Okay.
of the minutes.
Do,
Of the item.
do we need to go through a second rebuttal period, or is that saved for the?
This is not an official hearing, so
Okay.
rebuttals are not required.
So we can have a motion now.
All right. So I'll move to find a violation of 60.
Jurisdiction and.
Oh, I'll make a violation of.
Point of order. Could you clarify what you just
We,
said?
Well-
What's going to happen?
I believe
yes, we
that-
will. We will.
There'll be public comment, and there will be more for the vote. So I'm going to make a motion to find jurisdiction because the Historic Preservation Commission and the Planning Department are both bodies of the city. And then I'm going to add to that motion a violation of 67.16 for not making draft minutes available for inspection or copying within 10 working days after the meeting. And this motion would apply to the Planning Department and the Historic Preservation Commission.
Second.
Okay. Any public comment on the motion?
Members of the commission, Ray Hartz, Director, San Francisco Open Government. I really approve of the action you're taking. It seems like a very confusing issue, and as most of you know, many members of the public are only as aware of the Sunshine Ordinance as far as they see it on the back of an agenda saying, know your rights. In this particular case, we have the issue of who's responsible. Well, any organization I've ever worked for, whether it was the military or a private sector, whatever, if I'm the boss and I delegate to somebody to act on my behalf or answer on my behalf and they fail to do so, that doesn't mean I'm not responsible. If the request was made to the Historic Preservation Commission and the answer was done in an inappropriate way, they are responsible for it because the request was made of them. And if they fail to get the people who they delegate to do their job appropriately, then that is their fault. Now, the Planning Commission can also be found at fault because obviously the way they've structured this whole thing, that is their responsibility, and they failed to meet that responsibility. The question about how the meeting was handled and all that others, I agree, there will need to be additional complaints, but I think it's very similar to the experience I've had over the years with the library. Every single request of the 9 determinations I've got against the library were made to City Librarian Luis Herrera, and yet it's always Sue Blackman or Ms. Singleton who comes here and gives you the line, but you never get any clear understanding as to where they got that from. Did they talk about it with the Library Commission? Obviously not. I'd know about that. Did they talk about it with Mr. Herrera? Well, obviously, that's really kind of irrelevant, because if they responded on his behalf, if they did so inappropriately, he's responsible in any case. So basically what we have here is this sort of pointing fingers at each other, and the HPC saying, oh, well, it's their fault because they're responsible for doing our admin stuff, and then the Planning Commission saying, well, it's, I don't know what they're saying actually. But the reality is there is nothing wrong with open government. And if this project is open, the question I would have is their response to the gentleman for records was not an appropriate response. If someone submits an application in any form to the body, if they withdraw that, it doesn't disappear. The city still has a copy of the record of what they originally submitted. They just now have another thing requesting that it be withdrawn. So I think they withheld records from him also.
Okay, seeing no more public comment. Victor?
On that motion, Member Hensy.
Aye.
Hensy, aye. Member Moss.
Aye.
Moss, aye. Chair Kanada.
Aye.
Kanada, aye. The motion passes.
Should we take a second to just explain what just happened?
Mm-hmm. So, Mr. Lambert, for this complaint, what just happened was that through the discussion, the planning department admitted that they were late. So they're not contesting the complaint. So this committee forwards a recommendation up to the full task force. This item will be heard at the full task force at a future date. And we found that the Planning Department and the Historical Preservation Commission are in violation of 67.16. At that full task force, both yourself and the respondent could be there, but because everybody agreed that there's a violation, you're not required to be there.
Thank you.
Okay? And if you do have other complaints, file them and we'll work through it.
Okay, thank you.
You're welcome. Okay.
Next on the agenda. Next on the agenda, item number 6, file number 17073, hearing to review the Sunshine Ordinance Task Force public comment procedures for witnesses and the general public.
Okay.
Give me one moment, please.
To the chair? Mm-hmm. So did Chair Wolf give instructions for what we were, what we're discussing in regards to this, and what he's expecting from us to come from this hearing today?
My understanding is the discussion is around, and correct me if I'm wrong, the discussion is around the fact that the way the commission operates is that if a person provides testimony supporting either the complainant or the respondent, then they are not allowed to provide public comment. And at a meeting of the Education and Outreach EOTC committee, members of the public brought up the fact that they thought that the public comment referenced two different things. One was the merits of the case, and then the public comment on motions could be on process, and that's what the discussion is about. As to what the results are to be, I think there's a discussion, and the substance of the discussion will get passed up to the task force to.
We were expecting a call-in speaker to address the issue, but they have not called in at this time.
Okay. All right, so
Before my time is up, can we be told who is this call-in speaker? That may affect our thinking of what their views were potentially based on who it is.
I believe that Mr. Dave Snyder, a previous member of the task force, was supposed to call in, but I don't expect him to call because I haven't been able to contact him.
I'm unfamiliar with that person, so when you're ready, I'll start.
go ahead.
So I'm Bob Planthold. This arose from a previous committee meeting. The issue being discussed by the committee was whether the Ethics Commission had properly made a vote on a specific procedure. The complaint was ethics hadn't. I supported the ethics interpretation that what they did was acceptable within the interpretation of the law. What happened was then, when called for public comment, I was still sitting here and I started to say something and they said, you can't speak. That's why I raised the distinction between the content, I like or dislike one side, and the process where you can comment on the actual motion. Is it because at previous complaints hearings, I pointed out, you folks in the discussions didn't take into account what was said by X during the hearing. You didn't take into account or mention reference to a document that was in the packet. So to me, that's a process question. If the motion is properly responding to any and all information before you, that's a generic. But also, because I was allowed to speak, I pointed out that the Ethics Commission was complained about for failure to properly take a vote. I mentioned at the beginning of that same committee hearing in the decision on minutes, they didn't take, as required, a roll call vote. Instead, it was without objection. And I point out, even here, your committee made its decision on minutes without a roll call vote, but by acclamation was the phrasing from the chair. And therefore, again, to me, that's a process question. If a committee was going to find or recommend a violation by ethics for failing to take a proper vote, and the same meeting that committee itself failed to take a proper vote, it besmirches the committee's integrity. It tars and feathers the question of, is everybody really paying attention to A, what they're doing, and B, the ordinance? I also want to bring up, yesterday I was in a discussion with former Chair Washburn, former Chair Rick Nee, and longtime member Bruce Brugman, where we brought this up, that sometimes in the course of a discussion, enough information may come out to change people's thinking. And here again, I might support one side, but then because of what was said, I want to suggest, hey, wait a minute, think about this in your motion. So that to me is a process question. And again, Commission Chair Washburn and others said they thought they had done that other times to allow people to, after lengthy debate with new information, come back and comment on the motion, not on the content. I'm suggesting you folks ought to think about some clarification for the future to distinguish between content and process.
So just make sure I understand, if that's okay. So make sure I understand. Can you just walk me through one more time the step by step of what you did and why it was problematic? I don't need I just need the during the hearing, like at what point you spoke, at what point did you not get to speak?
During the hearing, they asked for witnesses for each side.
And that's when you spoke.
I spoke then as a witness.
You were during public comment.
And I also pointed out, nowhere was there mentioned in the material in print nor at the beginning of the meeting, nowhere was there mentioned a witness cannot use public comment.
Right.
And that was previous to my experience from the years I was on the committee, and therefore, again, it was like I was caught uninformed, unaware.
Yeah. So, I mean, I think that for me, one of the, in serving on this committee for about a year now, one of the things that's come up is that, when we call people to present facts and evidence, sometimes people come up and it is just expressing their opinion on what they think we should do, and that maybe that is not the appropriate time for them to express an opinion. the time, if they're there to say, here are facts, like here is a document, here is what I witnessed with my eyes, here's what I recall from an event, and not passing judgment on what they thought the event meant or what they thinks the committee should do about it. They're more like, they're not, the complainant is both, in a sense, like their own lawyer, their sort of pro se lawyer, and witness them themselves, because they're just, they're the victim. And when they pull somebody in that facts and evidence, that is pulling somebody who's going to be a witness. And so maybe as long as we define better what the facts and evidence is, and we stop people from making their opinions at that point, then those people maybe could go on to do public comment later. Mm-hmm. I mean, that's just one thought to think about.
Yeah, I can see the distinction between commenting on the case and then commenting on the process. So, in that regard, I don't think. Again, this is my own opinion. I don't think I don't think that we should stop the public who are there supporting an issue from commenting on the process also when the motion is made. I don't know. I've been thinking about this. When, should this ever apply to the principals, to the complainant or the respondent, where they should be allowed to comment on the motion? And, I don't know on that one. But, yeah, absolutely. This is.
So I want to comment on separate parts. What Member Moss talked about could be interpreted as still trying to allow people only one time. You're either a witness or a public commenter, and what I did was both and separate.
I think that's not what I intended. What I meant is that I'm just bouncing around ideas. Like, I'm not settled on what my opinion is. What I was suggesting is that if somebody is called as a witness to provide evidence, at that point they should only be providing witness or evidence, and then save the opinions for the public comment period. And that would help, because what we don't want to do is set up a situation where somebody just gets extra public comment.
Agreed.
And,
Two bites at the apple. Yeah. I understand, because that can be interminable loop. And here again, I'll just say, I think then that needs better statement on process from a committee chair or the task force chair when this happens. In regard to Committee Chair Kanada's comments about whether the principals ought to have public comment, let me offer this thought for consideration. You might consider that because the principal are saying, I'm right, no, he's wrong, I'm right, they might be biased. They may not be the ones to do appropriate public comment on the process of the motion. A witness, you would expect, as Member Moss has said, you expect to be somewhat analytic, detached, giving something substantive, factually based, not I like this, I don't like this. So you could come up with a distinction between maybe not for principals, but maybe for witnesses if they have a process comment. Maybe.
I would, and maybe I'm totally wrong here, but as I understand it, like, the Sunshine Task Force is exceptionally, like, we err on the side of transparency. When we have a motion, we might take public comment 2 or 3 times on a single item, and that isn't necessarily required by the ordinance or the Brown Act, and a lot of other committees don't. And so kind of what we're discussing here is, are we, by putting somebody in a capacity where they are, like, I guess I'm confusing myself here. Where we have public comment, we could have public comment at the beginning of everything, and I don't think that would necessarily be helpful to the task force, but theoretically on every item we could just start with public comment and then have our discussion and have our deliberations and then have a motion and vote. Like, we just don't do it that way because it's not conducive. But it does trouble me that if we're telling people, like, we need to, at the very least, we need to be clear that when people are, if the status quo is going to stay the same, then it needs to be clear and made explicit to people that when they come up to provide as a witness, that they're somehow giving up the ability to speak later. I find it problematic, and that maybe the policy needs to change, because it does seem to me that by providing being a witness, you are potentially giving up your right to public comment. But at the same time, I also don't feel like if you are the complainant that you should get another 3 minutes on top of the 8 minutes you got to begin with, plus all the Q&A we do with everybody, and then you get 3 minutes again to make your argument yet again. I don't know that I feel like that would be appropriate either.
Yeah, I generally have the same feelings about the issues. I don't think that people should lose the ability to comment just because they're providing facts for either side. So we.
If I could recommend public comment at this point.
Or just, you could recommend the task force reconsider and develop more explicit statement and education on this.
Right.
I'm interested to hear what the public has to say
Mr.
on this matter. So, you want to call public comment, I guess?
Public comment, Mr. Hartz.
Ray Hart, Spectre.
Give me a moment.
Yeah.
Okay.
Ray Hartz, Director, San Francisco Open Government. I agree with Mr. Planthold. It is a confusing process. All the years I've been coming to the task force, there were very frequently times when I wanted to say words supporting the complainant because I felt that their case was a valid one. Yet I knew that unless I waited until the respondent had made their comments, I couldn't really comment on the entire case. And so I would wait until public comment so that I would be able to either support or knock down one or other argument. And it is confusing in the sense that most people aren't going to be familiar. Most people who come to these meetings are going to be novices who get up and make a comment when they're asked to make a comment. If they feel one side or the other side is in a better situation, then that's just by luck of the draw. That's probably when they'll get up. But I think the most important point for anybody is the fact that when the motion is made and the body is actually going to take an action, that's when public comment is most critical. One of the things I've really always objected about with the Board of Supervisors is their rule that on the day they pass a law, you cannot speak about it during general public comment if it was spoken about or public comment was taken at a committee meeting. Well, basically, yes, I spoke at a committee meeting 3 months ago, and this law has completely changed now. And right when you're all going to vote for it, in fact, not just the 3 committee members, but all of you who are going to vote for it, I'm not allowed to talk to you. I'm not allowed at the very moment you're going to agree to pass this law to get up and raise my objection, which I think probably defeats the entire purpose of it. Now, it's convenient for the Board of Supervisors, and the Board of Supervisors do it because they don't want public comment. All you have to do is look at their record. I've gone to the Board of Supervisors at 2 p.m. on one occasion, and public comment was at 2:30. On another occasion, it was at 8:30 at night. So the public comment is put on the agenda for the Board of Supervisors in a way that, number one, all the nice people, all the people who are getting commendations and, all the friendly audience will be done with their business and leave before all the negative, nasty people like myself will get up. And so it's kind of convenient. Plus, it will discourage a lot of people. It will simply discourage them from coming. So I think, again, going back to Mr. Planthold's argument, there is a real distinction between providing facts. Where I think the problem is going to be is the slippery slope. It's almost impossible for most of us to get up and simply, what's the old Sergeant Friday, just the facts, ma'am? How many times did he have to say that during every show? And I think that's where you'd be to a degree.
I think the one of the differences that we can probably make more use of during committee hearings is, so when somebody speaks during the facts or evidence portion of it, that isn't like public comment where if we interrupt them, we have suddenly violated the ordinance, because it's not public comment at that point. It's kind of more, to me, like when somebody speaks to the Supreme Court or the California Supreme Court and they're given 10 minutes, but, half that 10 minutes is them being interrupted and asked specific questions by the Supreme Court justices because Supreme Court justices want something. And I think that if our process was a little bit more clear and we said, we need you to provide facts or evidence, and somebody gets up there and starts saying what sounds like public comment, it's okay for us to interrupt them and say, listen, if you don't have facts or you don't have evidence, please wait till public comment, and just sort of cut them off there, because they don't have like a right to go up and just go off on something that isn't per what they're supposed to be up there for. I'm not sure what kind of recommendation should we be making here. Is this something that needs to go to rules, or does it go back to us to having a discussion over this during? We were having a discussion, I know, at the last few committee hearings, the full task force hearings, about the procedures, the hearing procedures. What needs to happen?
May I suggest that we possibly continue this to the call of the chair, and then I can provide a copy of today's audio to the Chair Wolf, and I'll see how he wants to proceed with this issue.
Yeah, that's fine.
Yeah, I mean, I guess I can. Should I make a motion about moving this to the call of the chair? I can add a little bit more to that if that helps. I can try to make a motion. You guys just not second it if it sounds terrible. So I'll move to sorry, what was that you had said?
Continue to the call of the chair?
So I'll move to continue to the call of the chair with the recommendation that the procedures for the complaint procedures be clarified to address the issue of the parties presenting facts and evidence versus public comment.
Second.
Okay. Any public comment on the motion? Seeing none.
On that motion, Member Hinsey.
Aye.
Hinsey, aye. Member Moss.
Aye.
Moss, aye. Chair Kanata.
Aye.
Kanata, aye. The motion passes.
Can we put in there providing Chair Wolf with the audio?
I will do that.
You'll do it. Okay, fine. That's good. All right. Next item, please.
Item number 7, announcements, comments, questions, future agenda items, and pending calendar by members of the committee.
When is the next hearing scheduled?
That would be, I might as well bring up that issue right now. I was hoping that we could possibly change the day of the meeting for the Compliance Amendments Committee to move from Monday to maybe to the third Tuesday of the month, as Mondays are becoming difficult for me. It's completely at your discretion, but I just wanted to propose that if possible.
Would that be in we do it like the IT ad hoc committee where this comes before another
No,
committee?
it would.
We just open.
It would meet. EOTC meets on I believe, on the even months, and Compliance Amendments meets on the odd months. So you would be meeting on the same day at 4:00 every other month. And you would alternate with the EOTC for each month.
You're saying the third Tuesday?
I believe EOTC meets.
Wait, what date? What date? So what? Just when would under this scheme? When would the next committee meeting be?
That would be
September
the 15th, August 15th, or
September.
It would not be
Every
next
other.
month. It would be. The
oh,
month
sorry,
after.
that's right. So it would be September 19th.
Yes.
I'm good with changing the days. I don't have a.
And it'll be at 4 still,
It's your discretion.
but at 4 still.
That works for me, but
I mean, that's fine with me. I don't have an objection. I don't know about Member Highland.
I will bring it to his attention, and if he has no objection, I will present it to Chair Wolf at our next meeting about officially changing the meeting date.
Would that be okay for you, Victor, since you have complaint the next Tuesday every month?
I prefer the Tuesdays, just
Okay.
'cause, the thing with Monday meetings, it tends to interfere with holidays, and we start losing days.
You don't want to do it Saturday
Okay.
mornings. We can do it Saturday mornings.
no, we can't.
We already have a problem with too many meetings.
Okay, Tuesdays are fine with me.
Yes, and we can always change the time. I don't know if you want to move to a 5:00 meeting to make it more convenient for members, or
I kind of prefer 4, but,
Okay.
you know. I
That's
could be
completely at your
I could be
discretion at start
flexible.
time. It just has to happen after 4. We can't go any earlier.
Yeah, I mean, I could go later. You know, I mean, if we could do like 4:30, that would probably be slightly better for me than it is now.
Yeah, that could work.
Could we-
I'll propose that with the
is that
suggestion.
okay with you, though?
Yes.
Okay.
Well,
It's just
especially,
the Mondays are becoming difficult.
especially if we keep efficiently sticking to a couple of hours.
Yeah.
Like today was really quick.
Yeah.
Yes, I didn't have.
Oh, I've got like 50 minutes worth of announcements and future agenda items to talk about. No.
Well, start.
No, I don't have anything actually. Yeah, so 4:30 would be good for me, in part just because, you know, having to leave work from coming from here, it's a lot. It's leaving at work at 4 to come here at 4:30 versus leaving work at 3:30 to come here. Like it's,
Yeah.
you know, it's slightly more doable, and meetings end at the right time, and it's good.
All right.
I
So
feel you on that.
I'll inform Vice Chair Highland, and if he's agreeable to it, I'll present it to Chair Wolf.
Okay.
I don't have any other agenda items.
neither do
so.
Next on the agenda, item number 8, adjournment.
Oh wait,
Oh,
public comment.
Public comment, sorry.
Ray Hartz, Director, San Francisco Open Government. There is something that I would like this subcommittee to consider looking at, and that is, over the years, I have been promised on numerous occasions that somebody would look into the fact that you have serial offenders, people who are here all the time, who break the law all the time, who have been found to have broken the law all the time, like the library. All of my requests, all 9 that had been ruled violations, were all made to Luis Herrera, the city librarian, and yet he continues to send Miss Blackman and Miss Singleton in here with these BS explanations as to why they will or will not follow what the task force has agreed to, has interpreted the law as meaning. At some point, I think there has to be some issue of the fact, dealing with the fact that if I were to sell a product and I were to tell you that it would do certain things and promise you 100% guarantee that if you didn't like it, I would give you your money back, and then I gave you the product, it didn't work, and I refused to give your money back, you would take me to court and charge me with fraud. Well, the reality is, think about the Sunshine Ordinance. The Sunshine Ordinance says, here are your rights under the law. We have a task force which hears all the hearings, and yet none of them has ever been enforced, not once. So what kind of a law is it that you have when the people who are participating in it know that they have absolutely no chance of that decision ever being enforced? Now, this has been the Navy term that I would use, but I won't use it because it's not polite, between the Ethics Commission and the Sunshine Task Force. And the Ethics Commission just refuses to deal with the fact that they are, by this law, supposed to enforce your determinations. And yet they will, in the cases they do here, what they will do is come up with some reason why you got it wrong. And I believe that if you look at the entirety of the process, that's basically dishonest. I cannot honestly tell another body that is legally constituted, legally appointed, legally authorized, so forth, that they have gotten it wrong every single time. Never got it right once. You people, just because the law is yours and it says that you're the ones who to interpret it, we can come up with any sort of cockamamie excuse for telling you're wrong and then not enforcing it. And with the Ethics Commission, the real problem is they can't enforce it. They tried it one time, the mayor ignored them, and the bottom line is they aren't going to try again. Nothing is more embarrassing than trying something and failing. And that's what the Ethics Commission knows their position is.
Thank you. Okay, on the motion.
Next, item number 8, adjournment.
Move to adjourn?
Second.
By by rise and vote. Can we
Public
do-
comment on the motion? Seeing no public? Yes.
Awesome.